and march in a cooperative way on that road which is bound to lead us to unity.
August 15th, 1947. Seems like a long time ago. It indeed was. A 7.5 decade is a long period of time, though it is a fleeting moment in the history of nations across the world. The world was different then. India was different then. Namaskar, hello and a very warm welcome viewers. You're watching the special presentation of Sansad TV, The Amendments. As we celebrate Azadi Ka Amrit Mahotsav, marking 75 years of independence, we need to pause and reflect upon the landmark amendments to the Constitution that have shaped our country. These amendments highlight the transformation of the economy from agriculture to services, from shortages to surpluses, from basic survival to global goals. So get ready for this speed ride. A distinctive document with many extraordinary features, the Constitution of India is the longest written constitution of any sovereign nation in the world. The original text of the Constitution contained 395 articles in 22 parts and 8 schedules. It came into effect on January 26, 1950, the day that India celebrates each year as the Republic Day. It establishes the main organs: executive, legislature, and judiciary, defining their powers, demarcating their responsibilities, and regulating the interstate relationship. It lays down the basic structure of governance and the relationship between the government and the people. The rights and the duties of citizens are also spelled out. The preamble to the Constitution declares India to be a sovereign, socialist, secular, democratic republic and a welfare state committed to securing justice, liberty and equality for the people and promoting fraternity, dignity of the individual and unity and integrity of the nation. The opening and the last sentences of the preamble, we, the people, adopt, enact and give to ourselves this Constitution, signifies the power is ultimately vested in the hands of the people. India inherited an impoverished land from the clutches of British colonialism. Ours is an extremely hard-earned independence. Our freedom struggle is an epitome of unfathomable endurance, grit and determination, and the urge to excel, where there is nothing to fear but complete freedom to aspire and achieve. Leaders of India gave new life to the country, lifting the country from famished deprivation to food surplus status and creating infrastructure over barren territory for the benefit of the people. The Indian Constitution was enforced in 1950, and in the very next year, an amendment was introduced. The Act amended the Indian Constitution even before the first elections were held in independent India. There were 3 fundamental changes made in the Constitution through this amendment. It gave ways to limit freedom of speech and expression, supported measures to abolish zamindari system, and made it clear that the right to equality does not preclude passing laws that give particular consideration to society's most vulnerable group.
Also look at the context in which it took place. When the Constitution First Amendment Bill was introduced in the provincial parliament, the Constitution had been working for close to 16 months. During that time, the citizens of India had reached out to the higher judiciary to protect their fundamental rights granted under the Constitution. In many of these cases, the courts upheld the fundamental rights as were given and struck down laws that were passed by state legislatures in the country. When the bill was introduced, it faced serious opposition in Parliament and outside of Parliament. many members of parliament criticized on the floor of the House the different provisions relating to curbs that were going to be placed on freedom of speech and expression. Parliament then sent the bill to be examined by a select committee of the House. The committee comprised of senior members like Prime Minister Nehru, Law Minister Ambedkar, and opposition leaders like Shyama Prasad Mukherjee. The committee, when it gave its report, had 16 pages of dissent notes from all opposition members of parliament. In fact, the opposition to the amendment was so great that even the President of India, Rajendra Prasad, had expressed reservations in the way in which the amendment was being carried out. On the floor of the House, members of parliament questioned whether the provincial parliament had the right to amend the constitution, or should it wait for an elected legislature to come in and then amend the constitution.
The amendment paved way for reservation in India to mitigate lost opportunities due to the practice of caste discrimination. The reservations are a part of India's affirmative action initiative after independence that assured scheduled castes, scheduled tribes, and other backward classes representation in key areas. The Constitution First Amendment Act of 1951 gives powers to the states to make special provisions for the advancement of socially and economically backward classes. Article 15 was amended by the virtue of Constitution First Amendment Act of 1951, and Clause 4 was added to the Article 15, which allowed the state to make reservations for the scheduled castes and scheduled tribes in educational institutions. Reservations were put in place in Indian Constitution immediately after independence as means to recognize the historical injustice meted out to the people belonging to backward groups and to implement provisions by which they would have better access to resources and opportunities. Reservations in India were introduced to rectify the past and historical injustice against the backward classes, to ensure equal representation, and to provide an equal platform for everyone, irrespective of their caste, and to promote and advance the backward classes.
A clause was added to Article 15, Clause 4, which provided that the government can make special provision in favor of any socially and educationally backward classes of citizens or for scheduled castes and scheduled tribe. Now, question arises why the necessity arose to make this kind of amendment. We have to look this amendment in the context of Article 14, 15 and 16 of the Constitution, because all these three articles deal with right to equality, which is enshrined in the preamble of the Constitution itself. Preamble talks of justice, social, economic and political, also talks about equality of status and of opportunity. But this cannot be achieved unless you carry out the principles as enshrined in Part 4 of the Constitution dealing with directive principles of state policy. Therefore, Article 14 was extended further by Article 15 and 16, where Article 15 prohibits discrimination on the ground of religion, race, caste, sex or place of birth, and Article 16 provides for equality of opportunity in public employment. While framing Article 15, the Constituent Assembly made a special provision that for women and children an exception can be created. However, similar kind of exception was not created for the socially and educationally backward classes and for the scheduled caste and scheduled tribes. And if they have to be brought at par with other people in the society, then probably the similar kind of status which was given to the women and children for making a special laws for them was required to be made for the socially and educational backward classes as well as for scheduled caste and scheduled tribe. To achieve this objective and to give effect to the preamble of the Constitution as well as the directive principle of state policy, as exception was created by adding clause 4 to Article 15, which said that government can make special provision in favor of any socially and educationally backward classes of citizens or for scheduled caste and scheduled tribes. I make it very clear that so far as the implementation of directive principle is concerned, we know that even that implementation has to be done in accordance with and protecting the fundamental rights of the individual. Therefore, unless an exception is created in the article of fundamental right itself, probably this kind of law or executive order could not have been passed by the state government. So I think this was a very good amendment made at that time, because of which enabled the government to make policy to protect the interest of the women, children, as well as socially and educational backward classes.
The Constitution First Amendment Act 1951 added 9th Schedule to Indian Constitution. Laws contained in the 9th Schedule are immune from judicial review. The 9th Schedule was created by insertion of Articles 31A and Article 31B. Article 31A was inserted by the government in order to protect laws related to agrarian reform and for abolishing the zamindari system. Article 31B of the Constitution of India provided that any law in 9th Schedule could not be challenged in courts. The other feature of Article 31B is that it is retrospective in nature. That is, when a law is declared unconstitutional by a court and later it is included in the 9th Schedule, it is to be considered as having been that schedule from its commencement. Thus, it provides blanket protection to all laws under the 9th Schedule.
After the Indian independence, when land reforms were being brought about and the zamindari system was being abolished, at that point of time, the Patna High Court struck down the Bihar Land Reforms Act 1950. By doing so, it led to a deathly blow on the idea of land reforms and for later on, of course, abolition of the zamindari system. This was actually very precarious because despite the country wanting to move forward because of judicial scrutiny and judicial review, the laws of this country were unable to take off. Now, this actually troubled the leaders of then, and at that point of time, the fathers of the Constitution who actually thought about how do we really build this Constitution forward were thinking about a way by which they could actually ensure that such laws that bring about land reforms are protected from judicial scrutiny. And therefore came the first Constitution Amendment in the year 1951. So the Constitution Amendment of 1951, also known as the First Amendment, brought and inserted Article 31B. And this Article 31B was introduced to actually introduce the 9th Schedule into the Indian Constitution. What was the need of this Article 31B? This Article 31B provided that there were certain laws that are belonging to the center and the state that should be protected from judicial scrutiny and judicial review, and therefore such laws must be placed under the 9th Schedule. And therefore the Bihar Land Reforms Act of 1950, along with many such land reform acts, were placed under the Schedule 9. And this 9th Schedule ensured that the courts of the day were not able to strike them down or declare them unconstitutional, and therefore the country could progress further through governance in this process. One of the key areas of the 9th Schedule is presently, as on date, 284 laws of the country are actually protected under the 9th Schedule, which means that the laws made by the Parliament cannot be brought under judicial scrutiny, review by the Supreme Court or any courts of the land. Of course, there have been different judgments by the Supreme Court, including the Keshwanand Bharti case, in which the basic structure of the Constitution and the idea behind it was also discussed. But as a parliamentarian, when we think about making a law, there are many times we see that the honorable courts strike them down, especially the Supreme Court. But the 9th Schedule ensures that those laws that are brought about by the Parliament are provided reasonable safeguards and protection under the 9th Schedule. And therefore, in the greater goodness of the nation, it is necessary that certain laws stay protected.
The Constitution First Amendment Act of 1951 also provided that state trading and nationalization of any trade or business by the state is not violative of the right of trade or business if it is in accordance with the conditions that they are in the interest of state security, amicable relations with foreign states, public order, contempt of court, incitement to commit an offence or defamation.
Now, Article 19 also gives the freedom to practice any trade, business, and profession. The reasonable restriction that is placed here when the Constitution was originally made, that these should be carried out in general public interest. Now, while the government was hopeful that the existing provisions allowed for any scheme of nationalization to be taken up by state governments, it wanted to be abundantly sure that such schemes would not be struck down by the courts. Therefore, it carved out an exception that allowed for schemes of nationalizations by the government.
Each constitution has some technique for alteration whereby the provisions are changed by method of expansion, rectification or revision in order to suit the requirements of the present. The framers of the Indian Constitution were aware that the changes would be needed in Constitution from time to time. Thus, the provisions for the amendment to the Constitution were made in order to defeat the difficulties which may arise in the future. The authors of Constitution wanted to have a flexible Constitution, and they wanted to avoid extreme rigidity in the Constitution of India. They wanted to have the Constitution which could develop with the developing nation and which could change with the changing needs of the people. The success of Indian Constitution for a country as diverse and complex as India continues to intrigue, impress and inspire experts around the world. Well, with that thought, it's a wrap from my side. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.